So what caused the change? How did we get to a point where something that clearly states that Congress shall pass no laws, the First Amendment, also applied to state governments? Well, as we've talked about before, and we'll talk about in the next set of lecture videos, after the Civil War, there were three amendments that were passed. They were referred to collectively as the Civil Rights Amendments. The 13th Amendment abolished slavery. The 14th Amendment essentially protected slaves, and we'll get into that, a little newly freed slaves. We'll get into that in a moment. And then the 15th Amendment, which extended the right to vote, or expanded the franchise to include men, black men, so freed slaves. But again, only men, not women. And in the 14th Amendment, there are two different clauses. One reads, no state can make or enforce any laws that limit the right of citizens of the United States. Let me read that again. No state can make or enforce any laws that limit the rights of citizens of the United States. And then also, it states that all citizens are guaranteed equal protection under the law. The 14th Amendment was designed to protect the newly freed slaves. It was to essentially prevent southern states where like 4 million slaves lived, newly freed slaves lived, to prevent them from the southern states from passing laws that essentially found another way of putting slaves back into a different form of slavery. And just so you know, in the immediate aftermath of the Civil War, during the period they call Reconstruction, in fact, the federal government did protect many of those rights. But eventually that all came to a screeching halt, and Reconstruction ended, and a new sort of racial caste system, Jim Crow, replaced slavery. But that's not our topic right now. We'll be talking about that more when we talk about civil rights. But for now, I want to talk about selective incorporation. What changed? How come, even though the First Amendment says Congress shall make no law limiting all these different freedoms, including freedom of speech, why does it now apply to state governments? Again, the courts have done this. But as I said before, they didn't do it in one big decision where they decided that all limitations on the federal government apply to the states. They did it one limitation at a time. So in this case, I want to talk about specifically freedom of speech. Okay, and again, we're going back to this definition of selective incorporation being the process by which the courts decided that some limitations on the federal government also limited state governments. In a very famous case, I apologize for that. In a very famous case in 1919, it was called Shank versus the United States. Mr. Shank was the person who brought a lawsuit in this particular example. Mr. Shank was encouraging people to oppose the draft in World War I. So he was walking around, I believe he was walking around like recruitment centers and telling people that the war was a war between the capitalists and you should let the capitalists kill themselves, and then it'll usher in an era of the working people being in charge, blah, blah, blah. That was his argument. And so he was arrested for breaking a federal law. Now, one of the ways that we know that is it's Shank versus the United States government. He was arrested for breaking a federal law. But he argued that the First Amendment protected his right to freedom of speech. That if he wanted to walk around telling people not to enroll in the draft, not to sign up for the war, that the First Amendment protected his right to do that. And so he sued the federal government. And he was one of those rare cases where it went all the way up to the Supreme Court. Remember, I told you before when we talked about the judiciary that most cases don't make it that far. Well, the Supreme Court, in their ruling in Shank versus the United States, they said that, yes, that's true. The First Amendment does protect somebody's right to freedom of speech. But they can limit somebody's freedom of speech when that speech poses what they call a clear and present danger. A clear and present danger. And what the court said is Mr. Shank's speech created a clear and present danger. Now, mind you, it wasn't like there were a bunch of people listening to him and saying, oh, I'm not signing up for the draft. But the court allowed for the possibility that if he had the persuasive power to get people not to join the draft, then there wouldn't be enough soldiers and we would lose World War II. And so what they said was, yes, you have freedom of speech, and Congress can't make any laws limiting freedom of speech, but the federal government can limit a person's speech when it creates a clear and present danger, and Mr. Shank's speech created a clear and present danger, and therefore the law did not violate the First Amendment. Mr. Shank, you go straight to jail. Okay, now, hold on one second. So now, 6 years later, there's a new court case. Gillow versus New York. By the way, that little pause, for those of you who are paying attention, did you see why I paused? Anyways, you may have to rewind it to go see. I deleted something. In any case, in Gillow versus New York, what happened is Mr. Gillow was advocating the overthrow of the government. Right? Obviously something more serious than saying don't sign up for the draft. He's advocating for the overthrow of the government. Now, in Mr. Gillow's case, he was arrested as well, but was he arrested for breaking a state law or a federal law? Well, hopefully you said a state law, and the reason you know that is because it's Gillow versus New York, not versus the United States. Well, in this particular case, what Gillow argued is that the law violated the First Amendment. The First Amendment protected his freedom of speech. And that this law, that if he wants to advocate the overthrow of the government, the First Amendment protects that right. He's making the same argument that was made in Shank versus the United States, but now he's making a novel argument. He's saying that the First Amendment that says Congress shall make no law, limiting freedom of speech, also limits state governments. And the court agreed. They said Gillow's right. They looked back at the wording on the 14th Amendment, and I'll show it to you again. Remember, it says, no state can make or enforce any laws that limit the rights of citizens of the United States. Okay, so let's go back to the court case. They ruled that if states can't limit anybody's rights that they have because they're citizens of the United States, and if the First Amendment guarantees citizens of the United States freedom of speech, then a state can't limit that either. Makes sense. Perfectly logical argument. They said Gillow was right. And this was the first time that the courts had said, it ruled that when it comes to freedom of speech, it not only limits Congress, it not only limits the federal government, but it limits the state government. Now, it didn't apply to freedom of the press. It didn't apply to freedom of religion. It didn't apply to the Establishment Clause or the Free Exercise Clause or the Second Amendment or anything else. But they said as far as First Amendment goes, yes, based on the 14th Amendment, the First Amendment places limits on the federal and state governments. Gillow was right. Now, it actually didn't work out too well for Mr. Gillow, unfortunately, because remember in the Shank versus the United States, what the courts had said is the federal government can limit speech if it creates a clear and present danger. And therefore, it also follows that the state can limit freedom of speech when it poses a clear and present danger. And Gillow's speech, calling for the overthrow of the government, they said created a clear and present danger, and therefore the law did not violate the First Amendment, and Mr. Gillow goes straight to jail. But he made an important contribution in his court case to the development and the growth of American democracy and our freedoms, because this is the case where the courts decide, in regards to the First Amendment, limitations placed on the federal government also apply to the state governments. And then if you think back to our discussion in the judiciary, the Gillow case now becomes precedent. So the next time somebody challenges challenges a law because it limits freedom of speech to the state level, the court's going to look back to Gillow versus New York and they're going to say, you know what, the courts have already told us. The First Amendment not only places limits on the federal government, it also places limits on state governments.